Hi, chat. Hello. What the? Can you guys hear him? Hold on. Hold on, chat. All right, let's try this again. There we go. Oh, we had a little bit of a storm roll through, and it kind of killed all the power, and had to shut everything down just in case. I didn't want to fry everything because it got nasty. Came roaring out of the lake. It was like 80-mile-an-hour winds. Like, holy shit, everything was flying around. Like, you looked out the window for a minute, like you're in a car wash. So we're all set. We're all okay. So let's get started. Hope you guys have all had a nice day today. Now a bit louder. Yeah, well, it happens. Yes. Suffer Cleveland. Cleveland always suffers. That's the problem. That is always the problem. Let's see here, guys. All right, so we've got Sarah Boone. Sarah Boone had her first pretrial. And it's her first pretrial as her own attorney. Raptor says, are you going to cover any Young Thug developments? Yes. Well, there's a bunch of them now, including Little Woody took the stand again today, and he said, yes, I said I was going to kill him, and I was promised I'd get prosecuted for it. There are a lot of things happening in Young Thug. So we are going to work on that. Derek says, I'm in Southern Ohio, sun the rain. Well, sorry, man. But yes, I have not seen all the clips from today. I've been doing a little bit of work and doing a lot of work, this, that, and the other. So we will we'll work on that, and let's get this going. So here we go. Hey, it's potentially Sean. What's up? Not much. I hope you guys are doing well. So here we go. Let's get into Sarah Boone. Let's get into it with her and see what happened. Now, this was all yesterday, guys, and it's very interesting. I got the sound up. Yep, we're all set. And I don't understand why Court TV has got blurry camera mode, but Long Crime has better quality footage, so we're using them. So here we go.
Case number 2020 CF 2603, the state of Florida versus Sarah Boone, state.
State of Strong on behalf of the state. William J. for the state.
Ms. Boone, raise your right hand to be sworn, please. Please swear to affirm the testimony you should give shall be the truth, the whole truth, and nothing but truth, so help you God.
Yes.
Ma'am, good morning. Could you please state your full name and date of birth for the record for me?
Sarah Boone, 10/10/77.
I do see that we have a representative from
Chat.
JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay.
Chat, be aware, my lights are flickering and the storm is gone, like completely gone. It's sunny again. I don't know what's going to happen. You might lose me. Just so you're aware, Justice Administrative Commission, they are the people in charge of providing funding for people who are indigent or through court-appointed counsels and the public defender's offices, all that. That's the JAC you kept on hearing them talk about. So here we go.
Very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed costs to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. The defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense and trial dated July 18, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. and then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court, dated July 18th, 2024, and received July 29, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As for the depositions, the date are to be determined, and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for Prison Break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your.
Now, that's something we talked about, guys, and I mentioned this when I was looking at it. She isn't saying who, and she isn't saying what and where. And the fact she hasn't done that yet, to be fair, though, she doesn't have discovery yet. The judge is saying, I'll let you refile those again. Now, I still think that was a very good idea on her part, just to preserve the issue. I don't know if the judge would have denied it, but she did belt and suspenders stuff. She went the extra mile to make sure he can't screw her later. So, yes, that was a very good job by Sarah.
Defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to beat that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for, and again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those, so you're telling me at a later date once I have that information to revise them.
I'm giving you the opportunity to refile them. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts. and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts, identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid in support and preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid in support and preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
They're going to say
No,
law.
Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is asserted to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State, 152 Southern 3rd, 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State, 449 Southern 2nd, 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepherd v. State, 17 Southern 3rd, 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
Wow. Well, so guys, yeah, she's like, well, I want standby counsel. And he said, you don't get standby counsel. Standby counsel's for a pro se person that we're trying to save for themselves. You don't count. You've already shot that opportunity away. So therefore, you're not entitled to pro se. I'm sorry, you're not entitled to standby counsel, which, ooh. Judges, the judge put out a very reasoned explanation for it that is very likely to work and that will survive scrutiny. That's just a bit tough. That's just a bit tough, chat. Oof. So yeah, she's not getting standby counsel who could stand behind her. Now, Sarah, I think Sarah did think she could sit there and consult that person. Standby counsel is generally to tap in, and I've been standby counsel before. And you are hanging out, and after a while, you do tap in to help that person if they want it. But generally, there's only so much you can do to help them. So we'll see what happens to Sarah going forward here. But Judge Kranick is also. Do you guys like the overlay? I don't know if you guys noticed that, but anyways, here we go.
Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So you do not.
And that's a shame. I think you're correct, though. I think she would make standby counsel interpreting that. She would make them their bitch. I think very much so. I think that's a fair assessment. I would not want to be standby counsel for this woman. I would not want to be standby counsel for this woman. She would just be crazy. So, yeah, I would not want to do that. So, yeah. Very good. That's good to see you. That's a shame. Hope you're doing well. Yes. But yeah, Anna, it wasn't intentional. Yes.
And my standby counsel, which thank you to him for explaining to me what specifically it is. I don't want to be pro se any longer, so I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of the Ferretta inquiry, where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Ferretta hearing, is in regards to competency as opposed to having an understanding before you take someone's right away.
Ferretta pertains to a criminal defendants seeking to represent themselves. Ferretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what happened or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Ferretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my rights counsel. In my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promise you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay. I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
Okay, so you can't come in there saying, listen, judge, you're a big retard. Here's where you're wrong. And expect them to listen to you. I mean, that's just a general thing, and that's just people in general. But I do think that she is right to come in and say, look, you cited things and you made a record, and findings that are not correct. And if some of those aren't correct, she does have the right to come in and say, look, Judge, you got some of this wrong. Now, I'm sure Sarah's going to come in and say, it's all wrong, Judge. You completely got everything wrong. They're all in it against me. But overall, she does have the right to come in and correct the record. Let's see. What are you guys talking about? You can't be a meme. Australia's not real. Yeah. Yes, everyone is wrong except here. Oh. And then Fair Frozen 55. Thank you. Thanks for the super chat. He's saying her voice is annoying. She's whining about everything. Also, thanks for your kind words yesterday, Sean. But brought peace to my heart about my dog. Well, listen, it's haven't had to, that's the thing when you get older, that's the shitty part about age. Yes, it's wisdom. And it comes from experiencing stuff. And yeah, as long as you can say you did good by them, that's all we can hope to do. So, but yeah, thank you very much. And yeah, her voice, I don't know. I think her voice really isn't bad. I think it's her whole presentation with the Karen haircut and everything that probably torques you off more than anything. And then Simp for Sarah, he's been a member for 5 months, says, subs for Sarah, let's go! Yes, Simp for Sarah, chat. Simp for Sarah. So I do think, though, ultimately at the end of the day, if I was Judge Kranick, he probably could have done the Ferretta analysis. And the Ferretta case is about people representing themselves and making sure they fully understand it. He kind of warned her, but I don't know if she was properly warned. But ultimately, that's probably not going to be that big of an issue. Sarah's very competent, very savvy. I think they'll have determined she's given a waiver. Mavka says, could Sarah enter a restriction motion asking the judge of prosecution to be restricted from 8 to 4 if she's got that? You know what? Why not? That's actually... That's fair. You know what? It's a fair trial is a fair trial. Preparation is prep. That's... Yeah. Try it. I mean, here's the thing. What's the worst that can happen? The judge says no. So why not? Yeah, definitely do it. That would be a great issue on an appeal. Like, I was completely denied a fair trial. That would not be a bad idea. Simp for Sarah gets 5 memberships. We're getting that train rolling, chat, huh? Brimstone says there's no way she could have known that Cuck would asphyxiate the suitcase, not like she had done it previously. I don't know. We'll find out. It's a little weird there. I don't know. We'll have to see, because remember, she gave an interview, and we're going to get to that interview coming up in the coming weeks and whatever, chat. So we'll get to that. And then we literally just started, Stabby. Sarah's starting her pretrial. So here we go. Let's keep going, guys. We're also going at like 1.15 speed, just because.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pretrial was scheduled for September.
Okay, I think I know why they're doing that. And I don't know if you guys are checking along in chat. Why are they doing this? I think Judge Kranick realizes it's going to turn into an absolute dumpster fire of a case. This is going to be a train wreck. It's Judge Ted Cruz. I think he thinks this is going to be a disaster. And I don't blame him. It probably will be. It is going to be a shit show. Even if Sarah is doing everything right, it's going to be slower. It's going to be a mess because of Sarah. And it's not even her intentionally causing problems. But it's just she's not going to be as good. She's not going to be as fast. Jury selection is going to be very weird. Everything she does is going to be very weird. But also remember, it's going to be limits on how fast things can go and things going there. And Luke saying because he fucked up. Well, I think he's realizing, okay, God, if I force her to do this, now she's on her own. Yeah. Brimstone says worse than Darryl Brooks. Yes, because Darryl Brooks is doing the sovereign citizen bullshit. Sarah's gonna actually try to lawyer this one. She's gonna try to she's gonna strap on her boots and try to do this. She's gonna try to lawyer her way out of it. So it's really gonna get worse. It's really gonna be a mess. It's gonna take longer. And can she tell the court? Can she tell the jury she's forced to represent herself? No. You're not allowed to comment on rulings that happen prior to court. You're not allowed to do that. You're not allowed to bring stuff up like that. So she's gonna have problems. Luke is saying he had constantly forced her to do it so he could suffer. I don't think it's unconstitutional. You do lose that right after a while. Do I think in this situation it warranted it? I don't know. I don't think that an abuse of discretion analysis is an appeals court's going to find for Sarah. So. What are you guys talking about here? Wait, hold on here. I'll say Aletta Lee says, "Are you sure this isn't intentionally calculated?" Also, Aletta, nice to see you. If you're new, I don't think I've seen you around before. Are you sure this isn't intentionally calculated by the court or Sarah? I don't think so. I think the judge realized, oh my God, she is going to suck at this. I should afford more time. And it's easier to give yourself when you're the court, you're saying the schedule. It's easier to clear off your schedule now than at the end of week 2, and you're like, oh my God, we're not even close to being done. And then you got to clear out the field for next week. I still think about that person, and I guess Chad Daybell will get the death penalty if he's acquitted of all charges on a weekly basis. Yeah. She should argue nullification. That'll get her into mistrial territory, and the judge will order the jury to ignore it. I don't think the jury will. Remember, nullification is going to work when the jury seems to have some idea they're sympathetic to you. I don't think Sarah's going to come off as sympathetic, really. You're going to have to find somebody who wants to vote for her. Now, if she decides to be all simpy and she wears a suit jacket and nothing underneath it, and she gets, she tapes her boobs together and squishes them up, that might help her. But I don't think she. There's only one way she's getting out of this, so that's how I would phrase it. Then there's Hubbleson says even if this makes it the trial, I don't think she takes a plea. I guarantee you part of the issue is she has refused pleas and she has gotten mad at them for bringing it up. I 100% guarantee you I've had clients like that where you're like, listen, man, retained, court appointed, whatever. Hey, you've got, here's a plea offer, and I don't want to hear it. And you're like, listen, I have to tell it to you. They're like, I don't want to hear it. And I'm like, listen, I'm obligated to tell you what the plea offer says. You don't have to accept it. But I said, my job as an attorney is to tell you everything that comes to you, right? And they're like, yeah. I said, well, this is what's come to you. The prosecution has contacted me. If you don't want it, you don't have to accept it. But I'm just telling you, hey, man, let's come up with a game plan here. Okay? So that is a thing. So I don't think she goes. I think she goes to trial. She will not accept. I mean, unless they offer her manslaughter, which I kind of get the feeling I doubt they have, and I doubt they will. I mean, if she got a manslaughter, she's not. There's no guns, there's no weapons involved, so she's facing the lower end manslaughter. She's already got. So by October, she'll be like almost halfway through a sentence, unless she accepts that. I don't know. Kimbo says, I would bet money Sarah will get a mistrial and walk. She is really smart. Well, I have a feeling that's not going to happen, my dude. I have a feeling that is not happening. I admire your optimism. I'm just telling you, you remember, on the list of shit that's going to happen, this is not on that list. What if she does comment on stuff from the jury? He's going to tell the jury to ignore it. He'll punish her. Depending on how bad she acts during voir dire or during an opening statement, he can say, just like with Daryl Brooks, you have forfeited your right to continue an opening statement. You're done. That's going to be a nuclear option, but it's out there. I mean, I will say this much. Daryl Brooks showed how you can do it. Board Activity says, new to the stream. Well, hi. Stream, is a streamer a lawyer? Yes. Yes. My name is Potentially Criminal. My also name is Sean Martin. I am an attorney over in the Cleveland, Ohio area. I focus on a lot of criminal defense topics. I kind of do a little bit of everything, though. But criminal defense is like my wheelhouse. And yeah, we're talking about this stuff today. And yeah, like I said, I am a IR lawyer. I've been licensed in the state of Ohio for 10 years now. So thank you for being here. Serious question, Ronnie, and this is okay. Give you a serious answer. What happens in the middle of the trial? She stands up and says, I don't know what I'm doing. And the judge's gonna go. Oh well. Judge's gonna say, pick up the sticks. The fight's on. There ain't no surrendering. He might look at the prosecutor and say, like, go talk to her about a plea. But other than that, there ain't. It's like you hear those people when they're up, student pilots up with the pilot. It's like, the pilot's dead. What do I do? It's like, well, we better hope you figure out how to land it. But otherwise, Sarah's on her own. Let's see here. Let's keep going. All right. And we're going to keep going.
Or 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right, so pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed you, but some of it may have been reviewed based on counsel's representations. State,
Yes,
I want to address
saw.
with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want before pretrial. So let me just kind of lay the map for what the court's thinking.
Whoa.
The court
Hold
would
on
have
here.
the
Time out.
provide a exhibit list and a witness list.
Time out. My dude. Like, here's the thing, chat. I'm not the snazziest dresser in the world, but I do think there should be a little bit of decorum in a courtroom. Like, you're down in Florida, and homie, you're wearing your trench coat in the court. Like, pop that bitch off. Like, take your jacket off. Stay a while. That's a little much for me. Come on, man. Anyways, let's get back to like the actual important stuff here.
State. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense to me.
That does make sense,
Yeah.
and I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Now, he's saying, like, I'll give you a list of everything, but I can't be locked into it because trial could change. And judges trying to be like, look, I get that. I get things may happen. Like, you're not locked in. This isn't a suicide run. But do you agree to at least give her a thumb drive with all the exhibits you plan to show? That way, Sarah, and because she's in pro se, and because she's in jail, she's got limited time to work. This gives it it's almost like a limited pretrial admissibility issue. You're doing a hearing on pretrial admissibility of exhibits. Just that way, it gives Sarah a chance to do it. It makes it fair. This is a fairly streamlined way of doing it. I will give the judge credit for that.
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Now, obviously, that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said. I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. It's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
Yeah, it looks like he didn't have a sport code. Looks like he may have got caught off guard about this hearing or forgot about it. So I guess he had to wear a jacket, but it's just like, dude, that makes you look like a goober.
So essentially,
That's it.
so I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay. And that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list and the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think
That's a very good issue that Sarah brought up. Well, what the hell's going to happen? How are we going to make this quiet? You know, am I going to have everybody there? So, Sky's Neighborhood says, do I have a court trench coat? I have like a winter trench coat, but not normally outside of time. Like if it's warm out, no. Yes, he smells like gin with the trench coat on. Internet person, this is a good question. I'll just answer real quick. Would this not be a case that both sides are normally willing to plead on to voluntary manslaughter in 5 years or something? Yeah, except they believe she murdered him. She intentionally set this up. And given her testimony and given her statements to the police, I'm sure they believe this is straight up murder. I don't know why they haven't gotten a manslaughter. Maybe that has been offered and Sarah's just being an idiot. I don't know. I mean, she could. This is very real. Sarah's such an idiot. She could be pissing away a deal like this. I just don't know. I don't know. And then why do they dry clean lane coats? I don't know. I don't know. Oh, I don't know. So let's keep going here, guys. Let's keep going. She turned out 10 years, I heard. Well, she's halfway done. Guys, and a bunch of you have answered. If you guys have proposed questions, I'll be getting to those in a second. we just need to catch up here on this video.
Is pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise to autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. Those are my suggestions, and then later we can turn to her request and we can put on the record how we would go about going out to the jail to meet her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So is an option of reviewing what the state has with my investigator and then be able to come with the objections and everything?
That is correct.
I'm unclear on having all of my evidence being in sealed bags and for me to be able to inspect them to be here in the courtroom.
She does, and guys, this is something you may not know or understand. When it comes to evidence, you have, as an attorney, I have the right to examine those items beforehand. I normally don't, but I will at times. For example, if there's a weapon, I'll want to examine that weapon, and I will set up a time with the prosecutor. I'll say, well, I need to talk to your detective. I want to see this gun. I don't care if you put it in a bag, and I'll tell them, I need to handle it. I need to see it. Put it in a bag, put it in a big old evidence bag so I can just sit there and manipulate it. Or a knife or different items. If there's drugs, I want to go see those drugs. How are they packed? How are they found? Because the picture tells you a lot, like the picture of those things, but it's still something you got to see it in person. Like I told you before, sometimes you go to crime scenes and you take a look around, or for example, if my client, does a chase, I always drive the route of the chase if it's feasible, just so you get an idea what's going on. But yes, she should have the right to examine the physical evidence against her.
Know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even superfluous.
And that would be true for her. Having the media there while she's sitting there pawing through a pile of evidence bags, that would be a problem. And especially if she's stuck there in the jury box like that, which I think is a little asinine at that point. She should be at a table at some point. But she's going to have the chance to look through it. She's going to need some privacy, because that could reveal trial strategy, things like she has her own work product and stuff. So yeah, she would have some rights to have the media not have access to the courtroom while she's doing it.
That it's available on the internet, but at the same time, though, it is my understanding that it.
Brimstone, I'll get to this. Hold on.
I should have some right to privacy in reviewing my evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court, but then be finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, et cetera, would be addressed here in open court.
Just so the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in the presence of law enforcement, it's done in the presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence.
Well, and I guess I need to clarify, guys. Yes, people are there while you're watching it, but that detective doesn't know what the hell I'm thinking or doing. I may take notes, but Sarah's got nowhere to go. The camera's staring at her. I don't think the camera should be allowed in the courtroom while it's happening. I think she should be entitled to a little bit of privacy. Now, granted, the prosecutor and everybody would be sitting right here, but at least they're not looking over her shoulder.
To Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it can't be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better
Pretty
term.
normal.
And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing has been done.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive of research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So, if you
Sarah, you have no fucking idea. I've not heard of a case. Yeah, I'm sure you haven't. We've seen cases where the evidentiary hearings are televised. So quit talking, Sarah. Quit talking. You're making good points. Don't ruin what you've got going.
please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the after our viewing here in court, stays at your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane, who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously had worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain, whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
Steve Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get involved with their harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I didn't get to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you are speaking of in the meantime, I do not know, and it was served by process,
It was served by U.S. mail.
by U.S. mail?
Mhm.
Yes. I actually have 3 motions, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless,
Now that does bring up an issue for Sarah. It takes so fucking long for her mail to get out and then docketed. That's inexcusable. It's taking over a week. It's like 7 to 10 days or shit to get docketed. It's the same town. It shouldn't take that long. 2-3 days at most. That's a problem that needs to get fixed as well.
did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the two bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. Everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, it's going to be a feat in itself. So I want you to know if anything that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will on.
All right, guys, real quick. I know a couple people sent in some super chats, and there's some questions here I want to get to. Robert says, could Sarah hire a lawyer right now if she wanted to? Yes, she could. She's not prohibited from that. But that the judge has said, I will not grant continuances, so get somebody quick. Gene Williams says, how long is the trial going to take? 3 weeks. 3 weeks. Hella says, what are her chances at a fair trial now? Well, not so good, guys. And yes, excited utterance, doing hearsay for days, every Sunday at 4 p.m. Eastern time. And then she's got different shows throughout the week. Definitely somebody worth listening to if you get the chance. And then Aletta Lee says, what did you think of her ad for an attorney? I mean, it was clever. I'm just saying, it's funny it didn't work, obviously. Uncivil law, Kurt's comedy state, you might represent her. I think Kurt was more tongue-in-cheek because she'd drive anybody to insanity. So, Jermaine Down says pro ses can be successful. Yes, it's true. You can be. Just like people have performed surgery on themselves. Yes, some people have. I beat my daughter's traffic ticket distance with prejudice, but she can't win this. Yeah, and that's the thing. There are some things you can do on your own. Like I can wire up an outlet. I can do the brakes on my car. That doesn't mean I can rebuild a transmission. Or you want me messing with the turbofan on a 737. EDW Raptor says, and this is a good point, it's his raincoat that's in the middle of the hurricane. Fair enough. Fair enough. And then who's filming? Some news outlet, Long Crying, Court TV, somebody. And they've agreed to pool their footage. So one of them films and they both get to transmit. Future Mrs. Martin 2.0 gifted 5 memberships. Thank you, sweetheart. Jim Cox gifted 10 memberships. Thank you, Jim. Kat, not Williams, gifted 5 memberships. Thank you, Kat. Amica Cream, keeping them bruises at bay, gifted 10 memberships. EDW Raptor gifted 10 memberships. Oh, just making it rain, chat. Yes, as he says, put the grays in a suitcase. Then EDW Raptor with another 15 memberships. Thank you. Thank you very much. All right, guys. And then real quick, this one here. Brimstone, it's the last one, guys, and we're going to start back up. It says, does she have the right to deposition witnesses? She does have the right to depose witnesses. She doesn't have the right to depose every single witness, but expert witnesses. She probably has the right to depose, major witnesses in the case. But it's generally going to come down to expert witnesses and major fact witnesses. She'd have that right to do. But there's going to be limits to it. It's just like everything else. They will limit her if she abuses it. So here we go. Let's see.
Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
You can caveat in that order being, unless it hasn't already been done,
That's a reflection on the panel.
in case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence. here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator, and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get asked that one.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice,
Yes,
just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of looking on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where are we able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes, closed for the day at 4 p.m., I can therefore pick up using a hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make these type of deadline.
Well, we're setting them today.
I understand.
She's like, I'm not sure I want to.
The 3rd is what day? Thursday?
She's like, I'm not sure I want to do that. Judge is like, I don't care. We're doing it.
Today. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days, and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days.
I'm not going to answer that question. what now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay, guys, so there you go. We just heard some things. Well, that was interesting. Yeah. I don't know how to. Yeah, I understand, but I don't understand. Well, you don't understand. You better find somebody that helps you understand. I don't get this. How do I file an objection? I can't help you. It's like, woof, woof, chat, woof, oof, oof, oof. Getting rough. Getting rough. Yeah, this is getting real. Yes, it is. It is. Shit is getting very real very quickly. Means you have 62 days to prepare. It's like, fuck. He is not messing around with it right now. Yeah. Oof. Kimbo says, are they blurring her feet? No. It's the paneling right here that's giving off something. Because, like, here's her foot. You can see it. It's the paneling's giving a reflection. I know some of you guys have this, feet people. So there you go. Anyway, let's keep going. Let's keep going. This is guys, we still have like another 40 minutes of this, but that was the shit got real moment in the hearing. Woo. I mean, listen, you can hear a pin drop. You can hear a pin drop in there.
That would be me providing you legal advice, objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Now, if Sarah was smart, she should ask to have her writing hand unshackled. Because they should at least be able to do that. She's chained, chain her at the waist, and let her have her writing hand free. But once again, she didn't think to ask for that, but she should have. But God, you could hear the sound in that room. You're on your own.
Okay, and if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet, your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay.
What?
Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testified in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call.
Hold on,
that I
Kate.
do not have regular access to, and that I'm limited to only 15 minutes that I have to share with 62 other
I'm so sorry. I forgot to put these on. My bad. I apologize deeply.
inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? The protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. Did what I did? Yeah. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies, you'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone, I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to-be-determined deadline at this time. I understand that there's been some delays with regard to discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here, representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, make a state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these things which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to any more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it lie for good cause, I'm seeing my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after reviewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're speaking of, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceeding?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm going to have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have been known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here. All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
Sorry, chat. I see that. I see you guys. I see you. This is where he should be taking it and saying, look, you're sitting right there. I'm sitting right here. I'm going to give you a copy. We're going to wait 10 minutes while it gets typed up, printed. I'll sign it. We run it down to the clerk, gets file stamped. Boom, you got a copy. And then the idea of like, well, it'll get mailed to you. No, why isn't it getting hand delivered? You've got court deputies. Deputy, take this over there. Okay, here you go. This mailing it is actually, this part's getting annoying. This is getting annoying for this. That's the part I do not like. This is the part that I do not like. You guys didn't realize I muted it on the thing. Muted actually on the app, not on the mixer. That's the part I don't like. Let's see what this guy's about.
You can stay at the podium, sorry. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk, and go ahead and swear you in. All
Swear will affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir?
This part is good. He's forcing them to make sure everybody's on the same page. Because this is easily where stuff could happen.
Sir, good morning. Can you raise your right hand? Madam Clerk's going to swear you in.
You swear will affirm the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir, last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information, and you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those, this drive here is a copy of all digital discovery that I have in my possession from this Boone for the court's needs that they wish to facilitate that through it would be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers' boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, if you please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved?
I'll inform her.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 banker's boxes. Did you bring those back with you, sir? Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes? Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor, thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Blake, since he's here, would like me to sign my invoice or have Ms. Boone do it since she's pro se.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you can take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and you know, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think it makes sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I'd like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses inside of the county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, say, $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
Quick, guys, real quick. Couple questions you guys just like kind of threw up there. Board activity says, what's in the box? That's all paper discovery. And Robert's saying, does she get access to those boxes 24/7? No, it does not sound like it. Remember, she's in a dorm type setting, so she doesn't have like individual cells. What's she invoicing them for? Remember, because she's indigent, she can't afford an attorney. Her investigator is has to bill, and he has to bill the Justice Commission, and that's the guy here that he's the representative for at the JAC. And he had to sit there and take all those boxes and run them through a scanner and put them on the thumb drives. So because of that, that costs time and money, and he's going to bill them. But before he bills them, the invoice needs to be signed off on. And Sarah said she's technically the attorney, has to sign off on it. Now, if she had Attorney Cashman still, Attorney Cashman would sign off for it. So that's where we are right now with that. Those are very good questions. Very good questions. Rabbit says, are they going for the death sentence? No, it's second-degree murder. She faces life in prison, though.
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thanks, sir. Mr. Lake, thank you so much, sir.
Yes,
All right.
Judge Hayden,
Yes, ma'am.
what is his name, please?
That's Christian Lake. He is an attorney associated with the JAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
You will be
the
there.
site also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 20.
Board, you're saying they had to take a long time. I mean, he got a hold of they have high speed scanners, kind of like a copy machine, but even faster. You just shove a bunch of docs in and just it'll scan stuff pretty quick. There's some really good equipment out there.
4th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you, it was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's dates.
I haven't, is she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it's some type of notice. That's what brief that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it first? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
All right, I'm going to turn this down real quick while he's talking. Get through some of these other comments. Do you all think she wants to use a defense her lawyers had shot down? Probably. She wants to do something that nobody's agreeing to do. Yeah, apparently, like Kurt said, he was contacted by Sarah's team. That's the thing, though. But yeah, I think Kurt did the right thing by saying, like, yeah, I can't represent her or shouldn't. I mean, that's a murder trial like this being your first jump into the pool. That's a rough idea. And Zero Sum Salmon says, don't take my idea of knitting and providing trial commentary.
Ma'am, with regard to...
You're fine. I won't take that.
The motion for defendant's immediate address correction. As identified earlier, there was a clerical error using the general P.O. box as opposed to legal mail. That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
So her first thing to fix her address is fixed. That's all done. You guys think she really needs a big suitcase? Oh, 100% they are going to bring the suitcase into court. That's the murder weapon. They are going to bring that in. That's easy enough to bring in. They should bring it. If they don't bring it in, that's a physical object. But yeah, bringing it in a big bag, I would bring it in if I were them. And then Jonathan Dean, you asked this earlier.
Mr. J, if you want to approach, sir, to review the hand-delivered motions.
I didn't get a chance to answer this one before. I'd be concerned about handling physical evidence, so they've already tested for DNA. Well, here's the thing. A lot of that evidence will be in bags, or she's going to be forced to wear gloves. They don't just let her touch things. They're going to make sure there is no contamination. It's like if she took it, she spit on something, well, that's evidence tampering then at that point. Obstructing justice, new felony. So she won't do that. She won't do that. Like I said, there's always somebody from law enforcement with you. Like the only time it's a little different is like if you have a child pornography case and you have to go watch child pornography, you get to take the way it works is you do it in front of everybody. You're like, here's my phone. I don't have anything on me. Here, give me I have a pen and a pad of paper, and I'm going to take notes. And then you go into the little room where the child pornography computer's at that's been air gapped, and you look at it, and that's like the only time nobody sits with you when you're reviewing evidence.
Is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. The second motion is the motion for defendant to...
That's a good motion, Sarah. That's a very good motion. She's doing the things you should have asked for. I demand to be like my arms free. I shouldn't be shackled in the courtroom.
Lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, counselor, and just let me know when you're ready to address them.
Your Honor.
On a wall, real quick, air gapped means it literally has no way of connecting to the outside world. There's no Wi-Fi. There's no Ethernet ports. Basically, all the ports on it have been epoxied shut. There's no way to communicate with the outside world. Dolly says it's never sus. Look at that evidence. I mean, I have to go look at it to make sure it is what it is. I don't just take the government's word for it that it's that. Great Success says, you know, it'd be cool if all the evidence were in the suitcase. That would be fucking hilarious. If Sarah Boone came, wheeled the suitcase in and just open up all her files. Scott says, like, what, you get to watch that? I mean, like, well, nobody sits there with you watching and nobody wants to watch it. But yes, you're left alone. Like, you're there watching it. And you're like in a little closet at their office. Are these motions fired by our former attorneys? No, these are her own. And Chris says they don't airdrop you that stuff? No, they don't. Oh. Jail says, is she going to be allowed to wear street clothes? Yes. Yes. She has the right to not be in jail clothes. That creates a presumption of guilt. And it's highly prejudicial if she's seen in jailhouse scrubs. Now, her situation is going to be a little tough. She's going to have to work with her investigator, and he's going to have to get her measurements and her clothes sizes. And he's probably going to spend, like, you know, like one way you could do it is just like run up to, like, you know, Walmart and get her a nice top and a little jacket and a nice pair of slacks. I mean, that happens. Or like public defender's offices, over the years of representing people, they've gone and they have an amassed collection of shirts and jackets and pants and blouses and skirts that they've amassed over the years of representing indigent people, that they take them and then they keep the clothes get laundered, and then they kind of have them on standby. So, yeah.
In regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, of the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop.
Mm-hmm.
That laptop is being provided. At the last hearing, you advised that you wanted hard copies.
Yes, because she's only getting 8 hours of fucking access to the laptop, you fucking dickhead. Well, I'm giving you what you want. Yes, and then she's getting hamstrung. So no, this isn't her being unreasonable. She's asking for something, now she's getting fucked. She has the right to say, well, wait, I want to be unfucked.
Also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information.
Put her in segregation. Put her in seg for the next 60 days.
There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop that's been provided to you.
I never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, where I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, have the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited, restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created, and I'm just reciting what you've said to me at prior hearings, man. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy, and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag, a property bag, that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions as identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward, to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those 2 bankers' boxes. Ms. Barrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's 2 bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
my opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel, I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return.
That part's a little fucked up. He knew she's on vacation, and when Sarah's like, "Can I speak to the captain ASAP?" The guy's like, "I'll work on that." And they all knew she was on vacation, and none of them said a word. That's fucking sketchy. That is sketchy.
On the 12th.
So, if the document, what would be the process?
We'll get to that, Cedar.
It's marked, tagged, and in evidence, so there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two banker's boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those two banker's boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves Ori Tennis to release those two exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lane's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
Okay, so if she wants to Ori Tennis, which means oral motion, move to release those two exhibits, the state has no objection. And sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her that.
Ma'am, the state has recommended a position in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pretrial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it. If we need it, if we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been passed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, I looked at 8, please.
That is the 9th, ma'am.
The day before my birthday.
We're available, Your Honor.
Okay. Ms. Barrios will coordinate with
How are you not available? You're the prosecutor's office. You're available.
a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Nothing to say.
Anything else we need to address, Ms. Boone?
Please bear with me, yes, please, 1 moment.
Uh-huh.
What was the conclusion for the
Almost done, Chad.
issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd.
Thank you.
That's deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided, the names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you represent yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom? And during the evidence, should there be the physical evidence that I might be able to utilize that?
So my understanding is there was an imaging done on your phone with software called Cellbrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, Connor. And then that will be between you and the JAC.
Oh wow, he's actually helping, saying like, here's a guy they've used. That's very nice of him. He could have just been like, yeah, you got to find somebody. Who? I don't know. It's actually very nice of them to give her a hand.
About and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a mirror download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list for the mayor if I would have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all of that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we'll make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence. Because like you said, there's so much of it that would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what,
Have you found
based on
my
my
nude?
experience from other phone examinations is, all
Did you
that
like 'em?
information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
And that,
What
just
was that
as
date?
clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return to the jail.
Yes, thank you. None of it was,
She hasn't had it before, though, to be fair.
with Ms. Cashman or any prior, so this would be a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but
Yeah, but
do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. If it could be brought to you for physical, but the other physical.
So again, that's going to be something that requires an expert. And then if we get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have a full extraction and not just the PDF timeline of your phone, you're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you will supply.
No, what I'm saying is there's
Oh
two
my
different ways that I see phone.
a digital Cellbrite printout, if you print out, because I've gotten Cellbrite dumps before. If you tried to print that on paper, she's going to need half a banker's box for that alone.
Instructions. One is the PDF, which is what I think you're referring to, is the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes, I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No.
Okay,
It needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I mean writing a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it's uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you've already had my address correction, but I don't believe updated.
It's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or the portal or whatever it is I might be attached to in order to receive notices to be copied in here?
Notices have been sent now. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful. Thank you.
Yes, ma'am, thank you.
All right. All right, chat. Here we go. That's it. No, it's not box 4 time. It's not box 4 time. I'm not sure what you mean by suck it, dumb bird lady, but okay. And, well, thanks, board. You're welcome for being here. So she has a court date on the 9th. They are going to talk about security issues. Now, the problem is Fort Boone is going to be a lot smaller than Fort Brooks. She's only got 2 boxes, so there's not a lot of room to hide. And then let's see here. We got a bunch of things to catch up to. Yes, Amateur Iconoclast says, why accept 10 years when you get 0 years after you win? It's a very good point. Very good point. High Place Drifter says, I renamed my firstborn Sean in your honor. She's not too thrilled, but fuck her, I'm the father here. Well, Sean is in Ireland, Sean could be used for men and women. And That's a Shame says, we have a pro se trial coming up at my county, and our judge appointed our office, a public defender's office, just for the purpose of getting clothing for the defendant. And yeah, he has the right to not be in jail clothes, as it is highly, highly prejudicial. Can actually lead to a mistrial and can lead to reversals. Brad says they know she can't get all the stuff done. Yeah, but this is the kind of situation she put herself in. And then Cedar Rose for 2 loonies. Thank you. Is saying, does she claim innocence? What's her defense? I don't know what her defense is going to be. I think that the battered spouse thing is probably a defense, but given it's Sarah, who knows what it sounds like she's wanted them to do things they are not agreeing to. So I don't know. I don't know what defense she's going to try. DK says she has 8 hours every day, plenty of time. If you told an attorney they only have 8 hours a day to prepare for a trial, they're not going to accept that. That attorney has the right to spend 15, 16, 17, 18, 19, 20 hours preparing in a day on a case if they want to. And she's being denied that. And DK says, sorry, you're still in jail, which means you're not entitled to the comforts of freedom. Well, one of the comforts of freedom is she's entitled to have a fair trial. She's allowed to have an adequate defense, a proper defense. And that doesn't ever go away. So this limitation on her is kind of fucked up. Well, you get a laptop, but you can only use a part of the day. Well, give me papers for the rest of the day. No. How's she supposed to prepare? You know, that might not be enough time. And it's a appellate issue you can avoid by setting it up. The jail doesn't want to do it because they're fucking lazy. But if you set it up, then there's no appellate issue. Go the extra mile, save yourself trouble. Jasper says, Yana, can you climb into the suitcase for me? I don't know if he's going to do that, Jasper. He looks pretty big. And then Eric Rollins says for $5, Yana, I'm presumed innocent. The easy solution is to release me from jail. Lol. Yes, Eric, that's the best answer there. We'll try that. We'll see if it works. 4 years is a time for an adequate defense. Well, remember, she wasn't preparing all of that. Gene says, when her next hearing? The 9th. They're going to do the hearing about jail security. So, this coming Friday. Did I have a chance to read the Cleveland State Law Review article on forfeiture? No, and I agree. It's very hard to do, but at some point, otherwise Sarah would get the right to keep the trial going indefinitely. I think she should have the right to standby counsel in the background. I don't understand why they won't give it to her. I think that's, if the judge did it, it's like the one way he can guarantee not getting reversed. Doing this opens up to reversal. Casper says Sarah's accessing the internet to find trial procedure stuff. It doesn't make it's not clear if she does or doesn't. I could see them giving her an air-gapped laptop and then she's screwed. But she should have access in a library setting. I think she wasn't warned. She was warned, but not adequately. She was given some basic warnings like, I could fuck you over on this and you're on your own. And I don't think she was ready for that. JL says, how could all of her court-appointed attorneys be bad? They all weren't bad. Sarah was just being ridiculous in what she wanted. It sounds like in a couple of situations, Sarah's asking them to do things they're ethically not allowed to do, and that was a big fight. KC says, I had to give a 2-hour deposition today. No big deal, but I had to hold in a horrid fart for the last 30 minutes. Should have let it go to try and end it. Well, it's usually not bad unless you have one of those farts where it starts cramping you up inside. Feels like you're getting stabbed. Those are the worst. Luke says it wasn't even a fuck you over warning. It was, I'll look into it. Well, his warning, it wasn't that bare bones. But yes, he did leave a lot of out. He skipped ahead saying, you won't like it if this happens. And he didn't make it clear, this might be your last one. It wasn't this is your last one. I think that's the bigger issue here. Not saying, oh, well, I might burn you over this. You might get burned. No, you should say, you will get burned. Anna Wall says you'd have to prove it would make a difference, still, which it wouldn't have. Yeah. You have to. Here's the thing. People must make their actions intelligently, voluntarily, and knowingly. That's why there's set rules and set things you must say. If you don't do that, they can't claim her waiver was voluntarily, intelligent, and knowingly. So the warning was from the other judge, yes. But Kranick warned her too, but very, very cryptically. Suckett says 8 lawyers. It wasn't 8. 4 of them were conflicted. They had conflicts of interest they had to withdraw from. So it wasn't 8. Because they were not her fault. A conflict of interest she did not create. So it's not her fault. Will there be murder and manslaughter options for the jury? I doubt the state's going to be in a position where they'll want manslaughter, but Sarah's going to have to be smart enough to argue for manslaughter, and I don't think she will at the right time. So, Matt said she's still in counsel, so it wasn't that cryptic. This the judge did not do a good job of explaining that at that point. Rabbit Stick says, do you think Nick's governor will pardon him before he assumes his new office? You're presuming a lot here, like he's going to win, and I don't think that's going to happen, so no. High Plains Grit for $2 says, what is MAGA for $1,000, Alex? Maddie B says her counsel can explain it, no problem. Here's the issue. When your counsel is like, when you and your counsel have had a break, when your client and you have had a breakdown, you try to, like, at that point where, like, I don't want to talk to you, I want to fire you. You're really limited in what you can do. And here's the thing. I doubt she wanted to listen to her attorney. And her attorney's like, I'm not going to talk to her because she's told me to stop talking to her. Remember, she has ethical rules and obligations she has to follow. So that could be an issue for her. But no, I think the judge was very quick on the trigger to do this, and it was rather cryptic. So is it going to be structural error? I think it's going to be structural error coupled with all of this stuff. All of this stuff he's doing right now, where there's limits to what she can access, how she can access it, the way he's doing it. Yeah, this is all not going to end well. I think if this keeps going like this, she's going to have a lot of error in this trial. And it's easy enough to avoid. It's easy enough to avoid, Judge. You are the fucking judge. Order it to happen. You can order all kinds of shit to happen as a judge. And then you can demand they come in and tell you it's being done. DK says, what does she need to be handheld for? Special warnings now, too. He flat out told her it's a possibility. Well, that means it's arbitrary and capricious. That means the judge could decide, well, no, the judge needs to say, look, if you get rid of her, that's it, you're done. Not, oh, well, maybe it's up to me to decide whether or not you get another attorney. No, he should say, you are done if you do this. And he didn't do that. And I think that is a very, very big problem there. Because he already knew in his head he was going to dump her. DK says she'll sue them if someone gets a hold of a sensitive document. Yeah, but they're not worried about that. She can't handle a lawsuit anyway. So she can't handle basic motion practice. A lawsuit's going to be out of her wheelhouse. Because she doesn't know squat, period. Bob Smith says that would be prejudging. Not at all. Not at all. He's going to say, this is your last attorney. we're not giving you another one. I think he could have done this a far better way to give her a knowing, intelligent, and voluntary action, but he didn't let her do it. The other issue that comes up with this, they had that hearing she wasn't there for where Cashman was. That creates a problem. These hearings are being done. She's not being properly notified. Guys, remember, you start building up all these problems and eventually you have a massive pile of problems. So this judge is not helping himself. There's things he's doing that's right. I agree with, but there's some of it he's not doing well. JL says, what if she examines evidence and what's it not allowed in? I mean, at that point, she can object to it. She could say, I object on relevancy grounds. I object that authentication. I'm challenging chain of custody, whatever. She could try. There might be other issues too. Kat Madison says, will she be able to have an appeals attorney? Yes. Yes. She hasn't lost that right. But if she starts fucking around with those guys, certainly she could lose that right. DK says, that judge couldn't wait down, hand down that ruling. Sure. But that here, like one of those hearings that appears like she wasn't there for it, which is a big problem, especially if we're getting to the point of she's going to leave. Her attorney's leaving and she might be on her own. She should be at every goddamn hearing at that point. So that is a problem. That is a self-induced error that didn't have to happen. I just don't understand why it was done that way. T-Chatter says she'll be objecting a lot. Sure she will. But she's going to have to know the right grounds. Luke says Bankowitz ready to appearance over objection. Well, that's, yes. But I'm talking about the Cashman hearings. Those Cashman hearings, she should have been at all of those, especially when it became clear somebody was going to quit. Like, Cashman was looking to quit. She should have been there for all of them. And that's not good. Is the appeal of ineffective assistance removed since she was mandated to represent herself? Typically, yes, when you represent yourself, you waive that claim. But she can make an argument that she wasn't properly... If she can make the argument she wasn't properly stripped of her right to counsel, that it was improper, then she could argue, yes, ineffective assistance. Had I had competent counsel, this may have changed. But if the court of appeals is analyzing it and they get to step one and they say, yes, this never should have happened, they'll stop and not go any further. They'll immediately say, reversed, new trial. Matt says that the lawyer issue was her fault. The discovery jail issues are Brady, Sixth Amendment violations. I wonder if this is her goal. It could be. It could be. And yeah, it turns into an issue of, well, I only get 8 hours a day to prepare. It's like, well, that's not... I mean, Darrell Brooks had like forever to prepare. They brought his boxes, documents with him every day. You know, he had rights and all prepare all night long. So that, yeah, this was a bit of an issue. Like I said, the state of Florida and the judge and the jail are needlessly causing themselves problems, and I don't understand why. There's no point. I want to fix her. Well, yes, I don't want her to be able to have children, so yes, she needs to be sterilized. The Mighty Box Fort, yes. My friend says, no, Fort Boone's walls will be strong. I don't know about that. I think Fort Boone's walls will easily be overcome. X-Coomer, yes. The boxes should be suitcases. Well, kind of like my overlay here, the thing where I can cover up stuff with. It should just be walls and walls of suitcases. Did Brooks go through 8 attorneys before repping himself? No. He refused. He refused the public defender and just said, I want to represent myself. That was a little different. Have I stopped by a dispensary yet? No, I have not. I have not yet. Otto says, is there really a rule about how many attorneys? No. Technically, you could go through like 100 of them, but the court lets you do it. But it's up to the court to say no. The Boone barricaded boxes. And Island, yes. You know, yes, this is an issue here. She was the one who raised the space issue. She's concerned about the other inmates seeing her documents. Her complaints backfired. Yes, but that's where I think the jail should have said, fine, we'll put you in segregation. And then if she says, well, no, I don't want that, then she's completely done. They should have offered to put her in segregation. That would have taken care of it, I think, ultimately. So, will she be able to ask for a change of venue? She can ask for it. Whether or not she'll get it, it's the issue, and she will not. She does not. She will not get a change of venue. She would have to show there's no way for her to get a fair trial in Orange County, Florida, and that's not going to happen. This is one of the things where Robert Barnes is correct. You basically need analytical data to show this, and there's no way. Joseph Houghton saying the Ohio Fire Factory grows some fire CBD cultivars. Check them out. I will. I definitely will. I'm more of an edibles guy myself. Just pop a gummy or two, and it's just like, oh, feels good. Feels very nice. It's veteran owned and operated. Okay. We'll take a look. Let's see here. She doesn't know how to write an objection. She isn't writing that motion. Yeah. Well, hopefully she gets some access to the internet and starts working, or people in her pod advisor. I mean, a jailhouse lawyer is better than no lawyer. Kaz says that's what she said. Eric says, how many edibles do you need? I don't need that many. You like one or two edibles. Like, usually just one is enough, and I'm just like relaxed. Super nice. Super chill. Yes. Casey is saying an unfair trial. What about like 34 felony charges in New York City over something that was never defined properly? Yeah, no, that's a real problem. That's a real problem, man. It's a real problem. I bet she's antagonized them too. Well, I'm sure she has, but that's okay. She's allowed to antagonize people. Like, that's how it works. That's how it works, chat. Like, she might be an asshole to piece of shit, but you got to deal with it. They got to be professionals. Did I say she needs to start twerking or working? Well, she needs to start working, but if she gets convicted, she's going to have to practice her twerking in prison. I'm sure they'll be trading her around. So, yeah, guys, that is it for us tonight. Sarah is... Yeah, it's going to be interesting for Sarah. If they do have that hearing, we will air it. I'm not sure how it's going to go. And then from here tomorrow, we are going to be working on and going over Google was held to be a monopoly in a federal court. You're like, well, duh, they are, but it finally happened. We're going to take a look at that. The Young Thug stuff, guys, if I tried covering that today, what happened so far, it's literally still unfolding. We now had Little Woody take the stand again, and he said, yeah, they told me if I said I did the murder, they would charge me. And they said that never happened. Caleb Bumpus testified yesterday. Guys, this trial is getting out of control, but we're going to have to probably on Thursday just bite the bullet and just start addressing things. But tomorrow night, we're going to work on the Google monopoly issue, because that's going to be a big thing to get into. And what does it actually mean? Karen says, how's that not a confession? Because it's not a confession. And we also need to get caught up on Richard Allen, and I'm waiting on some more of the rulings from Judge Gull. So, yes, the Young Thug trial is completely corrupted, and I'm hoping I could get some special guests to come in on this if I could set it up and set it out, because there's a lot going down, and I think it's absolutely mind-blowing. Kaz, is it going to be bad as the Netscape case? Yeah. Not just Cat, guys, but yes, Cat is one of the people. There's other people as well. David Tamahere and George Wagner, but those could be later. Yes, those guys are going to be on their own things as well going forward. Who is... Well, that seals it. I'm getting Nick to come on. Yeah, ain't happening. Oh, and Gary Morrissey filed stuff. That'll be worth looking at. Yes, I am working. That's one of the people, but I'm also looking at the other attorneys involved in the saga. That will be fun to do. And yes, later tonight, DSP will be on in the casino. And we'll probably watch that over on Local. So if you guys want to join us over at potentiallycriminal.locals.com, you could join us. It'll be a fun time watching King Phil on the casino. The Nick hearing is in 2 weeks. Yes. If I get Max Shard, I'll send super chats. Well, I've got some feelers out on getting. I'm trying to get some people, chat. Like, I'm not gonna get Brian Steele, but I'll get Brian Steele's the guy who mows Brian Steele's lawn. How about that? How about that? That'll be my plan. All right, chat. So we will see you guys later, and until next time. Just because Sarah Boone did it, it doesn't mean she's guilty. At least not yet. At least not yet, chat. So, good night, everybody. And like I said, I will see you guys tomorrow, and we will be doing, we'll be hanging out in Locals a little bit later tonight. So take care, everybody.
Blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do,
8:30.
just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy?